Good morning, all.
Good morning, folks. Can you hear me?
Yes, I can hear you, Megan. This is
Great.
Ed.
Wonderful. I've been having some audio
Is that
issues
right?
recently, so I'm delighted you can
Where,
hear me. Great.
Meg, we
where
can't
are
hear
you?
you. We can see you, but we can't hear you.
Oh, you,
Oh, interesting.
huh.
You're on mute, Kit or Barbara. The commission is. Says it's on mute.
Hmm.
There's both
Ed, will
an
you say
appearance for
something
Kit.
so we can make sure it's not a problem on our
Yes.
end?
Yeah. Can you hear me? I'm talking to
Yes,
you.
okay. I think it's us,
Yeah.
not you. We can't hear anything on our end.
Okay.
You
Yeah.
still. Oh,
Ed, but
all
you
right.
can hear me, Ed, right? Yeah.
Yeah,
Okay.
absolutely.
Wonderful.
They seem to be talking to each
Mm.
other.
Kit and Barbara both have an appearance on Zoom separate from the Human Rights Commission camera. And Barbara's instances indicates it's on mute.
Yeah, strange. Although I don't think they can't hear either you or I.
But I was hearing Kit, wasn't I? She asked me to say something.
Yeah, we can hear them, but they can't hear us for some reason. What about now? Can you hear us?
Go
No.
to at the bottom of the microphone, little microphone icon, out of that, down at the bottom of the screen. On the
This here?
yeah, click on that little up arrow.
What about now?
Very different,
Can you hear
very
us?
different speaker.
Where are you, Megan?
I'm at home today.
Oh, okay.
Yeah, I was on a run yesterday and I took a pretty good fall on a
Oh,
trail.
wow.
And so I think I
Oh,
might have. Oh, can you hear us?
Yep. All right, can you hear us?
Yes, we can hear
yeah.
you. Can you hear us?
Yes. Can you hear us?
Great. Okay. Well, I was just telling Ed that I am at home today because I was on a yeah, I was on a trail run yesterday and took a pretty good fall, and I think I need to get my ankle x-rayed. So
Ah.
I know it serves me right, right, for getting outside and getting some exercise, but I can't seem to catch a break. So I'm at home today, but happy to be here through other means.
Yeah, I hope you've got some good painkillers.
What's that?
I hope you have some good painkillers while you're
Yeah,
waiting.
just ibuprofen and some, ibuprofen and acetaminophen seems to control it mostly. So I don't know. I don't think it's broken, but oh, what a mess. Although I heard that when it happened, I was very graceful. I
Some
apparently
consolation, huh?
I apparently managed to fall down in a way that was exceedingly graceful, said with all the sarcasm that you can probably tell already.
Yeah. Just- I literally broke it. So. John. It's a nice special term for being yelled at, obviously, for like being lazy. Like, she's very good. Having looked like
Jay, you're doing any work with them?
and you'll.
I did get a hold of Mark. I did get a hold
Yes,
of Mark.
you
And he-
We've got daycare parents. I don't want to start him right. Back to school given.
Oh, I know. I know.
We've had. Thanks, Jen, honestly, because she's the organizer.
Thanks.
Thanks.
Like. Now she like. She's like 14. Over. Well, like for my house, but longer, it's like. It's indiscriminately. One. Oh, yeah. Don't think that's any problem. All right. If I do not learn knowledge.
We are gonna do, quarterly reports today. They were supposed to be on the August agenda, but obviously the August is a marathon. We'll do quarterly reports except for the case inventory report because, I'm fighting for our internal database about drafting create reports. I have a meeting with our 14 tomorrow, so I should email that to spread.
I'm not sure I heard that, Ken. It's sort of muffled.
Yeah, sorry. Archie has gone back to school. And so I have whatever germs are going around at school. So if you can't hear me, let me know. I will try to speak up and more slowly than usual.
Okay.
I was saying we'll do quarterly reports today. We were going to do them in August, but obviously I wasn't here and the August agenda was already quite long.
So the quarterly reports are under what?
I'll do them after the usual business session reports.
Yeah, but where are they published on the OneDrive? Under September memo, actual
There
case
is-
summary?
They should be in the business session folder.
Yeah, that's what I'm looking at.
Yeah, they're in your email too. I sent them to you.
Okay. All right, we all set?
Yep.
All right. Good morning, folks. My name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, or whatever, to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in the back of the room and online. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission will vote on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one, relevant factual errors, two, relevant omissions from the report of facts submitted during the investigation, three, relevant issues and questions concerning interpretations of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you come to the podium. First order of business will be adoption of the published agenda and consent agenda. There were no amendments proposed, were there, Kit?
Nope.
So I would entertain a motion to adopt the agenda and the consent agenda that's before you.
So moved. Second.
All right, and our remote participation policy requires the commissioners to indicate their vote both visually and audibly. So if you are in favor of the motion, I will vote yes. Commissioner Davis,
Yes.
Commissioner O'Brien, yes. Commissioner Douglas,
Yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
And the minutes of the August 25th meeting have been circulated and are before the commissioners. I found them acceptable and had no corrections. I'll make a motion to accept, and then if there's any discussion, let us know, please, commissioners.
Do I have a
So
second?
moved.
Second.
Moved and seconded. Any discussion? All right, thank you to Michael and Barbara for taking such good notes. I know that meeting was a monster.
I can tell you it's easier if you don't ask for discussion.
I only reminded you once, I think. I decided. All right, so hearing no discussion, if you are in favor, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien, yes. Commissioner Douglas,
Yes.
Commissioner Walker.
Staying, I was absent.
Right.
Good call.
Sorry.
Commissioner Sanders.
Yes.
And so that brings us to director's report. Kit?
All right. So for personnel, we have no changes since the last meeting. For compliance, we have a memo. We have two cases technically in active conciliation, although in one of them where the respondent has declined. We just haven't reached our 90-day window to officially fail conciliation in that case. Two unsuccessful conciliations, no agreements for you to approve. For investigation, we've had 50 new charges with a total of 73 respondents, 9 administrative dismissals, 1 right to sue letter, 3 withdrawals with no benefits, and 4 cases that settled either. We're trying a new thing now. We're counting cases that either settled in private negotiation through the commission's mediation program, or during investigation, because what we find is often, even if those are private settlements, they've settled because of something that has happened during the course of the investigation. So I'm just trying to sort of parse that out. Adam Lee, who's the representative on the judiciary and also practices here, asked about it at I don't know, one of the days I was up there, and I thought that would be an interesting thing to just for us to track, see how often cases are settling after investigation. So 2 settled during investigation, 2 settled through the commission's mediation program, with a total of $16,750. For the quarterly report, you have a budget report from Michael. If you have questions, please ask Michael. You have a memo about training and education. The commission staff has attended 18 events and I apologize, I believe that's for Q4 of last fiscal year. And I would give you a case inventory report, except that there is no good way to do that right now through our internal database. I'm meeting with our support team tomorrow to try to fix that and a bunch of other things. So I will send you a case inventory report for the end of FY 25, hopefully by the end of the week.
So I had a question, Kit. Kit, this is Ed. I had a question on the conciliation report. So that first one that says complainant accepted and respondent declines, it's not just failed yet because of the time. They would still have time to change their mind. Is that what it is?
Yeah, so the commission has 90 days to complete conciliation. We can't send I'm just waiting for the door to close. We can't send the letter that says conciliation has failed before those 90 days have expired. So we're just still in the 90.
Okay.
You can see the 90 days is at 11/23. On November 28th, Jane will send a letter saying conciliation has failed. I suppose if there was accepted suddenly and we could get something scheduled and done in those 90 days, we would still do that. But for the moment, just hanging out waiting for that 90 days.
Okay. And there's the fact that one party accepts and the other party doesn't change anything. They both would have to accept, right? Right. Thank you.
Yes, I do have a question on the budget. I'd like to, I don't know what's different, but I understand some of the line items better. So thank you, Michael, for that. If you changed it or if.
I did make a change to it.
You did?
I did.
Yeah, I thought so. Thank
I
you.
split it out for salaries and all other.
Okay, but it's expended at the top, expenditures through Q4. Is just so, is that meaning the whole?
That's correct. So if you look at expenditures through Q4, underneath that, you'll see the entire period for that.
Right, so okay.
Yep,
So
that's the
it's
entire
the whole-
fiscal year,
Okay,
correct.
okay.
We have not spent $1.6 million in the last quarter. Oh my.
Yeah. I think.
I wish. I'm not sure what I spend it on,
Yeah.
but
It'd be nice if we had those.
I'll do my best. I don't have any new business. The legislative session hasn't really gotten started yet, although I have started getting emails again. They're doing some work sessions. Nothing we need to do. Budget season is starting, but I don't have anything to tell you as of yet. Questions on any of that? Shall we be adjourned until 8:45 then? Oh, you're muted.
I beg your pardon. Yes, we'll be in recess for 5 minutes and start the hearing cases at 9:45 promptly.
8:45.
8:45.
Great.
Depends on what country you're in.
Yeah.
9:45 for me. So I have 8:45. We'll call the meeting to order.
Great.
The, fir- the first case for hearing is Ann Royal, versus Ankle and Foot Associates, Associates of Portland, claims of sex discrimination and retaliation. The investigator's recommendation is for no reasonable ground findings, and therefore we will hear first from complainant or counsel.
Do we have somebody here for Ms. Royal?
I'm right here.
Okay, great.
Good morning.
Good morning. Before we get started, I just want to remind everyone who will be presenting today that the commission's confidentiality requirements, both statutory and regulatory, require that you not use the name of any person who is not party to the case. The investigators have given those people pseudonyms, so please use those or just their titles. Ms. Royal, you have 10 minutes. Do you want to reserve any of your time?
I'm not sure what that means. I'm sorry.
Oh, yes, I forgot this is the first one. So you have 10 minutes total. The respondent will present after you. You can save some of that 10 minutes to respond to what they say. If you'd like to save 2 or 3 minutes to do that, you can. You don't have
Okay. Okay. Do I start telling my story? Is that what I'm doing?
Sure. Do you want to save any of your time?
Sure. Yes, please.
Okay, I'll start you at 7 minutes, okay?
Okay.
All right, go ahead.
So I was at work and I had finished up what I was doing at the medical assistant's desk, and I went up front to help the 2 girls up front. You said not to say names, correct?
Correct, thank
Yep.
you.
And one of them was my manager, and I was helping do their job because they were behind. And then it was 3:30 and I leave at 4, and I said, do you mind if I leave a little early? And she said, only if you F-U-C-K me. I'm sorry, I didn't want to say that out loud. And I just stood up and she said, just go ahead. So there had been a lot of things happening there. At this time, I was already approaching other jobs. It was a very uncomfortable place to work. She often would walk around the office imitating one of the physicians, getting a, I don't know how to say this profession, oral mouth job because he had had an affair with somebody in the office. And she would walk around doing that. This office was so unprofessional. I had never seen anything like it in my life. You know, instruments weren't properly cleaned, needles and medications were right in the hallway. Just, it was in awe of me because I've worked for Mercy Hospital for 12 years and I am now with Maine Health Nephrology. So this truly did happen to me. I don't know how to give any more evidence than the honest truth. And that did happen to me. And after they approached her, and then I was blamed for walking out. I never walked out. I never did that. It was my time to properly leave the office. At lunch, I went to lunch and I came back and there was a sticky note that she wanted to meet with me. And I said, of course, I just need to do it before I leave. And she came out maybe 5 to 3 minutes prior to me punching out and said, no, we have to meet. And I said, I can't, I need to leave on time. And I said, I can come in earlier in the morning if you'd like. And she just turned around, put her hands up in the air and told me to F and leave and never to come back. I don't know what else to say. That's the truth.
Any commissioner questions for Ms. Royal? None?
Yes.
Oh, yes,
Yes.
Commissioner David.
Yeah, Ms. Royal, the report says that the respondent wanted to investigate the complaint that you made about the sexual comments and that you did not cooperate with that. What is your response to that?
So what happened was I went to lunch. I came back. There was a sticky note on my desk saying that she wanted to speak to me. So I went up front, and professionally, she shouldn't be asking me that anyhow. That would be something the doctor would sit down, and he did. Dr. Pinchator was absolutely wonderful about it. And so I went up front. I said, I'd be happy to meet with you. I just have to meet before my punch out time. And she said, well, I need you to stay on the floor. I said, of course. And I've ran that floor by myself, but there was 2 of us there. And I said, just long we meet before I leave and, before my punch out time. And then she came back literally 3 to 5 minutes before I was punching out. And she said, okay, let's meet. And I said, I told you I truly need to leave on time. I had a doctor's appointment with Dr. Stockwell. And she turned around, put her hands up, and said, just effing leave and never come back. And that is what happened. And I know the other doctor heard that happen. It was the most unprofessional thing I've ever seen in my lifetime. I didn't
And
walk out
the-
early. I did not. I was leaving on time of my time to leave. And I did say, if you want, I'll come in early in the morning and we can eat meat. And that's when she put her hands up, turned around, told me to F and leave and never to come back.
Okay.
Thank you.
Any other commissioner questions for Ms. Royal? Commissioner Sanders?
Thank you. Ms. Royal, on the last page of the investigator's report, the investigator draws a conclusion that the employer terminated your employment not for a retaliatory purpose or motive, but on account of significant and prior performance issues. Even if we set aside the sort of the second incident of what the employer characterizes as you walking off the job, the investigator notes one other instance of you walking off the job without permission, excessive absences, and unprofessional behavior, such as disputing routine work-related directives. And I'm curious, do you discount that rationale for terminating your employment, or do you disagree with what your employer has told the investigator was the reason for your termination of employment?
I totally disagree. I was not unprofessional, and I can have multiple doctors and surgeons vouch for me. I've never been unprofessional at work. And that day we had a meeting, we all had a mandatory meeting, and one of the girls came from the other Yarmouth office. And my manager was standing beside me, and she was sitting beside me, the girl that came over. I'd never met her, and it was nice to meet her. And we're talking. And my manager came in and said, you need to leave and get out of here. You are not welcome, to the other employee. So I turned around and I said, why did you just say that to her? And my manager started tapping me on the shoulder and saying to mind my business. And this is none of your business. And I did say back, it's everybody's business, because you just said it in front of all of us employees. You made it our business. And then she did one of her fits and left. And then I went in to talk to Dr. Pinchator and Dr. Heber. Am I allowed to say that?
I don't believe those names are not in the final report.
I'm so sorry. I'm sorry. I went in with the 2 physicians, and I explained that, things that she has done to me, and like she's put insubordination on this great big board behind my desk and put what it meant and left it up there for like 3 weeks. I almost wiped it off, but I just didn't want to get into that situation. And that day I was bawling my eyes out. I was shaking, and I looked for her to tell her I was going to leave, because I was in no position to go back on the floor with patients. And I went to tell the doctors, and then one of them was raising his voice to me, and I grabbed my pocketbook. I was crying, and I told one of the other MAs that I was leaving, and they understood, because I was shaking and crying, and I have depression, so I do cry easy, and I try to control that, but I do cry easy. But it was just the most unprofessional thing. I have been an MA for 28 years, and I've never, ever, ever seen anything more unprofessional. than what happened in that office.
Ms. Royal, can I ask a clarifying
Of
question?
course you can.
You've made reference to girls a few times, and I just want to be clear when you mean or when you say girls, do you mean colleagues
Yes,
in the
employees. Yes,
okay.
yes. I'm sorry. Yeah,
Okay, right.
yes.
I just want to make sure that we're
Yeah.
referring to folks using standard, normative professional
Yes.
language. So thank you for that.
I was trying to transfer to the Yarmouth office, but then all of this went down. So I just,
Okay, thank you.
you're welcome.
Any other commissioner questions from Ms. Royal? Seeing none, you'll have about 7.5 minutes after a respondent presents. If you wouldn't mind muting yourself until then, just so we don't get the feedback.
Okay.
Thank you. All right, Attorney Snyder, you have 10 minutes. Do you want to reserve any of that time?
Yes, please. I'd like to reserve 3.
Whenever you're ready, go ahead.
Thank you. I'm going to try to be brief. I'll defer primarily to the investigator's report because I think it's comprehensive and lays the facts out in a clear, concise manner. This is an example of a relatively short employment relationship that was rife with documented performance issues, from serial attendance issues to, multiple instances of insubordination that were handled with, consistent with the progressive disciplinary policy of the employer. And there were 2 instances that employer would characterize as employee Ms. Broyle walking off the job without permission. I do want to highlight briefly the last paragraph of the investigator's report because I think it really defines the crux of this case. Complainant's discharge immediately followed her decision to walk off of the job rather than attend a meeting, which had been scheduled the day before. She had been noticed the day before that this meeting was going to occur because of a text exchange that had happened with the supervisor about work-related issues. Ms. Royal, had an issue with the directive that she had received from the supervisor. This meeting had been scheduled via text message the day before. Ms. Royal chose not to attend that meeting. And the meeting was scheduled notably before any report of sexual harassment was made to the employer, and could not have been the motivation for the meeting. Moreover, the supervisor did not know of Ms. Royal's complaint when she scheduled the meeting. Even after Ms. Royal chose not to attend that meeting, walked off the job, and was subsequently terminated, the employer still investigated her report of sexual harassment and asked her to participate in that investigation. Outreach, Ms. Royal readily admits she ignored. This left the employer unable to complete the investigation. To the extent that Ms. Royal is now claiming that her serial absences were due to her depression, this diagnosis was not contemporaneously disclosed to the employer, nor is there documentation to support the proposition that her absences were disability related. Ms. Royal never asked for a disability-based accommodation. What the record does show is that Ms. Royal was asking for time off for personal reasons, including her birthday and babysitting in Boston. This late disclosure does not change the analysis. Similarly, I believe she reports an earlier report of sexual harassment in her letter of disagreement. This was not raised at all during the nearly 2-year investigation of this matter. She raises this allegation now for the first time following the investigator's report and conclusion. There's just no documentation to show that earlier report of sexual harassment occurred. What the documentation does show is that upon receipt of her report of harassment, the employer took the report seriously, affirmed the report, and investigated promptly to the extent that they were able. There's no discrimination or retaliation here, and the commission should uphold the investigator's findings. Thank you.
Commissioner questions for Attorney Snyder?
Yes, Attorney Snyder. So I think you've explained what my confusion was and what when I was attempting to ask the complainant about not participating in the investigation. The investigation of the sexual harassment, you're telling us, was after she left, and she did not participate in that and blew that off. The meeting that she's saying, in response to my question, that was a meeting about disciplinary issues and performance and
That,
absentees. Go ahead.
Correct. Yeah. So there was a meeting scheduled. If you look at the text messages that were appended to our initial response, there's a back and forth that happened between the supervisor and Miss Royal. And it sort of ended with the supervisor saying, we're going to have a meeting about this tomorrow. That's the date that the ultimate discharge happened, that following day when that meeting was supposed to occur. That morning, prior to when the scheduled meeting was to take place, Ms. Royal made the sexual harassment report to the owner of the office. And before there was any opportunity to do any investigation, this discharge happened. The owner did follow up with Ms. Royal after she left employment to try to, investigate this incident. He did follow up with other employees at the office to see, if there was merit to the complaint. But Ms. Royal did refuse to participate in the investigation. So it's sort of
So
where.
you're clear that the scheduled meeting was about performance issues, and they didn't even know about the harassment complaint about that time. It was just made that morning. Am I understanding that correct?
That's correct. So the supervisor, in partnership with the doctors, had scheduled that meeting the day prior to address this instance of insubordination that had happened via this text exchange.
And you referred to a progressive disciplinary policy. Was this the first step, or had there been a prior write-up or warning or documentation of issues?
Yeah, and so I believe the record shows that there had been a couple instances of write-ups for attendance and one other instance of insubordination. And so there was a policy in place at that time that Miss Royal had sort of restricted ability to take PTO during this period of time because of her history of serial absences. She needed like a medical note to take any time off during this period. So there were a couple of instances of discipline.
And my question is, you're clear that those were documented, not just being
Yes,
referred back to as history. They were documented as incidents that needed to be addressed that she knew about.
yes.
Thank you.
Any other commissioner questions for? Seeing none, you'll have about 6.5 minutes when we come back to you. Ms. Royal, you have 7.5 minutes. Do you have anything else you'd like to add?
Yes, and I did sign that paperwork that she wrote me up for that. And the insubordination was when she was tapping me on the shoulder and kicking an employee out of the office. And I did not raise my voice. It was not insubordination. It was just an employee trying to make another employee not feel so bad. And she didn't need to be tapping me. If anything, it wasn't my insubordination, it was hers. And I was going to meet with her that day. She did not make an appointment for a meeting. She did not set up a time. She just put a sticky note on my desk and said, this afternoon. And I went up and I said, yes, just let me know when you want to talk. And she waited until it was my time to punch out. And that is the exact truth. And this employee literally told one of the doctors to F off. I don't like your effing tone. And she left the office and never came back to that office. And one of the doctors wrote that right in this paperwork. He also said it on an unemployment phone call. And that's why I did get unemployment, because it was just awful. And I did have a note for any time I was out of work from my doctor. Every single time. And yes, I get sick easy. I do. But I was not unprofessional. I did not do any insubordination. And this was about sexual harassment that did happen. And if I have to take a lie detector test or anything you need me to do, I will do it. This whole case was about sexual harassment. I'm not sure why it got against me so meanly. I don't know why it went like that. I am a great employee. I can show you all of my reviews. There was no policies given there at that place. When I got hired, they took me in for an interview, looked at my resume, and hired me in an hour. Didn't even call references. I didn't do anything wrong there. Even one of the doctors in my unemployment calls said how wonderful an employee that I was, and that the patients loved me.
Any other commissioner questions for Ms. Royal? Commissioner Douglas?
Yes, Ms. Royal, good morning.
Good morning.
Yeah, so I just want to give you a chance to talk about the timeline right around the time that you left employment, because I think that's a problem for you in terms of establishing your case. And in terms of your comments, before you answer that question, I just want to be clear with you. Nobody is here to say that you experienced sexual harassment or you did not. We don't know that, right? What we're here to determine is whether or not, once you made your report, number one, your employer's actions were appropriate, right? And we're also here to try to determine what their motivation was for ending your employment. Do you understand? So no, I just want to be clear with you. Nobody is here deciding whether or not you actually experience sexual harassment right now. Okay. So getting back to the timeline, I think the issue that we're having here is that, the report says that, you made a report of sexual harassment to the owner, right?
Yes.
The owner didn't pass that along to anyone. At least that's the owner's testimony in this case so
Oh,
far.
yes, I understand that.
You
I
understand what I mean? And
Yes,
so the
I never.
supervisor is gonna, right, so the supervisor is gonna have this meeting with you. And so far as we can tell right now, the evidence is that the supervisor didn't know about your complaint. And so I wanted to
No,
give you a chance to address that.
no, I never even ever said that. Because of the day before and the way I was being treated, I spoke with someone, a friend that is a lawyer of mine, and he said that I should do this, and I should tell about the sexual harassment, and I should have said it before, but I was looking for a job. And I know that she didn't, I don't think it had anything to do with that. And I never said it did. Everybody keeps saying I walked out and didn't say I'd meet with her, but that is not the truth. I went up after my sticky note. I said, I'll meet with her anytime. She just needs to take me off the floor, but I can't meet after work. And she said, okay. But then she came and got me then. So I was never sat down and signed anything or, sat down professionally. She just put her hands up, said, effing leave and don't ever come back. That's how I was dismissed from that office.
I understand. And I understand that you feel that you've been treated very unprofessionally. I understand that as well. But you agree with me, right, that this meeting that was going to happen was scheduled before you made your report of sexual harassment?
Yes,
You
yes.
agree with that? Okay.
That's
All right.
why I keep saying that yes, I told her I would meet with her, and then she just didn't come out and get me.
All right. Thank you, Ms. Royal.
Of course.
Commissioner O'Brien?
Thank you. Good morning.
Good morning.
It sounds like I would have a problem working in that place. That's not the issue at all. But we have to ascertain if you were discriminated against on the basis of sex. And the fact that, if I'm understanding this correctly, the fact that when you, I guess, Lee, how would you have proposed and would you have proposed that this be investigated and dealt with? You made the report, it was going to be dealt with the next day. Am I correct about that?
I believe so. He was wonderful about it when I explained it to him, and he wanted it in writing, and
Okay.
I never got a chance to do any of that because
Okay.
you told me to
But
be there.
that's the issue. That's what we need to.
Oh, I'm sorry. Yeah.
To ascertain if, you were sexually harassed and they did nothing about it.
I think they were going to.
That's the point.
Yeah.
That's the point.
Yeah,
Okay, just wanted to get it clear. Thank you.
you're welcome.
Any other commissioner questions from Ms. Royal? None. Thank you, Ms. Royal. Attorney Snyder, you have got 6.5 minutes left.
I am all set unless anyone has additional questions for me.
Any further questions for Attorney Snyder? Seeing none, we've heard from the parties, and next we'll hear from Jane O'Reilly, who will be presenting them.
Good morning, commissioners. I was not the initial investigator on this case, but I did complete the investigation and write the report. I don't have anything to add, but I'm happy to answer any questions.
No questions for the investigator. Seeing none, thank you, Joanne. All right, so we've heard from the parties and the investigator. At this time, we're looking for a motion. There are 2 proposed findings. Mr. David, you're muted.
I'm sorry.
I'm talking to
Yeah,
Commissioner.
I tried to unmute it with the space bar, but it didn't seem to work. I I will move that we find that there are no reasonable grounds to find unlawful discrimination on both counts of sexual harassment and retaliation.
Does that mean you don't think I got sexually harassed?
Ms. Royal, I'm going to ask you that means that the commissioners are voting to uphold the findings.
Oh, okay.
If you could mute yourself now, that would be.
Oh,
Thank you. All right, do we have a motion? Do I have a second?
Second.
Then moved and seconded. Any discussion?
Yeah, I just want to say to Ms. Royal here, as I said before, and you just said it. You just said, does that mean people think that I wasn't sexually harassed? No, nobody thinks that. We don't know if you were sexually harassed or not. What we are saying, and I believe the way the vote is going to go, is that you're just not going to be able to make out your claim of discrimination today, in part because your employer investigated, right? They did investigate, which is what they have a duty to do, right? Once you make a complaint, they clearly tried to investigate this. That's number one. And number two, the timeline in this case clearly shows that this meeting that they were going to have with you was scheduled before you made your report of sexual, harassment, discrimination, and that therefore the meeting could not have been generated by your report. So I just want to make sure you understand that, it's not that we feel that you were sexually harassed or not. It's just that based on the facts and the timeline in this case, you're not going to be able to make out your claim, I believe.
so my claim was that I was sexually.
Ms. Royal, we're done with presentations at this point.
Oh, okay.
Any further discussion? Seeing none, the motion is to find no reasonable grounds on both recommended findings. If you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien, Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
So the findings, there are no reasonable grounds on both recommended findings. We appreciate everyone's participation. The commission will send a letter to the parties and to council explaining what the next steps are.
The next case on the agenda is Mandy Alley versus Bread of Life Ministries. It's a housing and public accommodation case. The recommendation is for finding of no reasonable grounds, and therefore I think there's just the one count. But in any case, we will hear from the complainant, from Ms. Alley or counsel.
Mr. Alley, yes, Mike Spalding for Manley Alley, and I'll reserve 2 minutes.
Oh, I beg your pardon. My bad, Mr. Alley. Yes.
Whenever you're ready, Attorney Spalding.
Yeah, just so briefly to review the facts, Mr. Alley lives with Crohn's disease. In April of 2024, he was admitted as a resident of the Bread of Life shelter in Augusta. A few weeks after being admitted there, he did have an acute problem with his medical condition, went to the hospital, was discharged and returned to the shelter. And then on May 26th, had another acute attack of Crohn's disease, went to the hospital, was initially told that he was going to need surgery to relieve the fluid buildup in his body. Told that to the shelter, but it turned out the fluids came down with antibiotics. And on May 28th, he did call the shelter to say that things were looking up. He expected to be discharged from the hospital soon. And then on May 29th, he was discharged from the shelter after a caseworker named Lisa Brown apparently contacted.
Attorney Spalding, please don't use the names of people not named in the complaint, not named in the, who are not named parties to.
Okay.
They've been given pseudonyms in the report if they're relevant to the case.
Okay, so even if their name's in the report, we don't use their name here. Is that
Their name shouldn't be in the report unless they're named parties. They will have a pseudonym like caseworker or something like that. Was that person one of the named respondents?
no.
Okay,
No.
then please don't use their name.
Okay, so caseworker had contacted the shelter in the morning of May 29th, 2024, and put in the progress note, Manley says he had been in the hospital for the last 3 days, first reporting he had surgery, and then stating he had not. He was exited from the shelter by the manager. Now, that progress report's the only piece of written evidence we have that was made at the time. It doesn't say anything about this 3-day policy to turn over beds when somebody's out for, not in their bed, which is what becomes the explanation in the respondent's answer. Mr. Alley was discharged from the hospital later and started calling the shelter a number of times to retake residency there. And in July, one of his last calls, or maybe his last call in late July 2024, he spoke to an employee of Bread of Life who asked him if he still had his medical condition. He confirmed it was a permanent, condition, that he still had that. And she told him he can't return to the shelter with that medical condition. The investigator's report said that Mr. Alley admitted during the IRC that he was confused about what that employee had said in late July 2024. That there was a portion of the investigator's report where there's some confusion by Mr. Alley about Bread of Life's policy of how they were saying that they're not a hospital. They can't take people who are more appropriately housed at a hospital. But he didn't express any confusion about what this Bread of Life employee told him in July 2024. So I believe that was a inaccurate statement about what the record of the commission's and the IRC shows. Mr. Alley, again, so on this issue of the 3-day policy, I question whether that was actually the motivation at the time, because again, the only piece of written evidence we have suggests that they were mad or frustrated with Mr. Alley for initially saying he needed a surgery, but then it turned out he didn't need a surgery. The Bread of Life has said that this wasn't a policy that was set in stone, and we certainly haven't seen any written in-house policy about a 3-day turnover requirement. And but assuming for the sake of argument that this was a neutrally applied unwritten policy at the time, I believe the shelter should have recognized that Mr. Alley was making a reasonable accommodation request. Assuming that it was a policy, he's asking for a departure from the 3-day policy because of his disabilities. And that analysis was not done by the investigator. There's no failure to grant reasonable accommodation analysis. And I believe the elements here could have been met based on his condition. And then I guess the other issue that I take with the investigator's report is this notion that Mr. Alley's reporting of what was said to him in July 2024 doesn't make sense because the shelter has rented or, has provided beds for other disabled people, or the fact that they knew that Mr. Alley had Crohn's when they initially admitted him in April of 2024. I think, I can't, that would basically, that type of reasoning would prevent any person whose race or disability were known to the landlord at the initial inception of their tenancy from being able to bring a claim because the landlord knew of the condition at the time of the initial lease up. I think it's more inferable from the evidence that because of his 2 trips to the hospital while he was there, that the shelter come to view him as a high needs. This was essentially a high needs disability, a disability that was disruptive to their operations, and after having experienced, Mr. Alley as a resident there with Crohn's disease, they told him, well, you can't come back here with your medical condition. Those are the main points I wanted to make, and if I happen to have any more time, or I'll be happy to answer questions.
Mr. O'Brien. Thank you. Good morning. When you began speaking, I just want to clarify because it may make a difference. I think, did you say that he called, we're going back to the May 26th time, 2024 time period? Did you say that Mr. Alley called the shelter on the 28th and was told he could not have his bed back? On the 28th. 29th?
This is my best understanding of the timeline, is that he went to the hospital on May 26th.
Right.
On the 28th, he had that conversation with the caseworker. There's no written evidence of that May 28th call, but he basically told them that he was optimistic that things were looking up, and they didn't say anything to him, but basically they encouraged him to keep calling back or keep them posted about his developments. And then on the 29th, that's where we do have this one piece of paper called the progress note by the Bread of Life employee that says this one sentence suggesting that Mr. Alley had been deceptive about needing a surgery, and he was discharged from the shelter that day.
Thank you. Okay, so
did I not answer the
no,
question?
you answered it. I just
Okay.
So are you asserting that he was discharged or whatever it's called because of a high needs disability? I mean, I know, or I'm assuming that at the shelters there are very high needs disabilities that I mean, all the time. I mean, can you talk about that a little bit more? Your assertion as to why he was. was troublemaker, or what why do you think he was not given the bed back?
I mean, what his understanding, what we have, it's the written communication that we have suggests that he was discharged because he had been deceptive about needing a surgery. That's the only contemporary. But I think if even if we assume for the sake of argument that it's the neutral application of a 3-day policy, which is what the respondent says now, my position is that the shelter had everything it needed to know that Mr. Alley was making a reasonable accommodation request to depart from that neutral 3-day policy. And he perhaps didn't use the magic words of reasonable accommodation, but they would know about his disability and the other elements of that needed to depart from that policy. And as Mr. Alley explained at the IRC conference, his position was, yeah, he would understand that if he was out, partying or using drugs, that he would be discharged from the shelter to make room for another resident, but that being sick at the hospital would be kind of like getting an excuse at work. If you have a doctor's note, you're going to get more flexibility from your employer about returning to work than when you don't. And the shelter, knowing all of this, did not, leave a bed available for him to return to when he was discharged from the hospital.
Thank you.
Any other commissioner questions for Attorney Spalding? Yeah, Commissioner David.
Attorney Spalding, it seems to me that you're suggesting that anybody with a disability would be entitled to an exception from that policy. It seems to me to prove too much. It's not a reasonable policy for a shelter that has a waiting list of people experiencing homelessness and need those beds to say that if you're gone for 3 days, then we're going to go to the next one on the list. Why? I don't quite understand that. I mean, we look for some sort of animus. At least I look for some sort of animus when I'm upholding a claim of unlawful discrimination. And you say that animus is because you say he was a high needs person and they wanted to get rid of him. And I don't quite see the evidence for that. How do you respond?
Well, I guess I would say I believe that they should have still gone through the reasonable accommodation analysis about whether, because of Mr. Alley's existing disabilities and the request that he was making, it was reasonable to depart from what we now are claiming to be this. Again, it's an unwritten policy about turning over beds about over 3 days. But no, I think there was some conversation at the IRC that simply because I'm not maintaining the position that any person, I guess, making this would be entitled to, leapfrog the waiting list simply because they have a disability. But I don't think it means we get to ignore the analysis completely for when a person is making a reasonable accommodation request.
Okay, but you analogize this to tenancy. You've mentioned that a couple of times. It's not a tenancy; it's a homeless shelter. I mean, what comes to my mind is no good deed goes unpunished. They're trying to serve as many people experiencing homelessness as they possibly can, and he was gone in violation of that policy. And you say that was a pretext because he's a high needs guest. Correct?
Yes, I believe that his history of having to go to the hospital basically demonstrated to Bread of Life that he was not a suitable candidate for their shelter. There was a lot of conversation at the IRC where the Bread of Life was saying, hey, if somebody's should be at the hospital. We're not a hospital. They should be at the hospital, which, it's hard to disagree with that. Obviously the shelter
Right.
doesn't
It's
have the
hard to
facilities.
hard to disagree. Right. It's hard to disagree with that, isn't it?
Yeah, but I guess my position would be that when a person is discharged from a hospital, that is basically that's a stamp of the hospital saying you're no longer appropriate to be in a hospital. You are appropriate to be in some other type of facility, like a shelter or your own home. But so when a person is discharged from the hospital, that they shouldn't be, they're not considered appropriate for a hospital anymore, and they should be eligible for the shelter.
He was. He goes back on the waiting list.
Well, he
That's all.
again, I mean, he tried. It did eventually do what they called their pre-intake, was put on the waiting list. They have this uh, policy where the person on the wait list has to call back multiple times to express and renew their interest in getting a bed. He did that several times in July 2024 and ultimately culminated in this statement by the Bread of Life employee that he couldn't come back to the shelter because of his medical condition.
Thank you.
And I'll just, that employee didn't participate in the IRC. Apparently, they stopped working at Bread of Life in March of this year. So for people who have personal knowledge of that conversation, we only have Mr. Alley's testimony.
Further commissioner questions, Commissioner Sanders.
Good morning, Attorney Spalding. I infer from your presentation that you have questions about the veracity or legitimacy of this, what we're calling a 3-day policy. I note, though, in the investigator's report that the policy, right, is tethered to a regulatory scheme, right, and or a funding expectation. And so, the policy isn't just the policy because that's what the shelter came up with. The policy is in place because their funding requires that they implement that structure for shelter guests. And so, again, as Commissioner David questioned you, I'm having a hard time getting past sort of the policy as applied here to your client, right, is the policy that's applicable to anybody who's similarly situated. And so I think that's part of what we're struggling with here. Policy was applied. Staff, it wasn't clear to staff when he would be discharged from the hospital. And therefore the process and procedure that the staff uses for everybody is then implemented. And so that's, I think, what we're struggling with.
So I'll just point to the admission of any written policy, 3-day policy, that the Bread of Life didn't provide any internal policy documents that this is a policy of theirs. They didn't provide any regulatory or contractual agreements with Maine Housing that demonstrate this policy. I don't believe that to be the policy because of my conversations with Maine Housing. That's not part of the record, and I understand that you can't use that today. But but I'll just point to the lack of what I believe would be a written documentation to have this policy. And I do believe that during the IRC, Bread of Life said this was not set in stone, is I believe the phrase that was. So it's not a strictly, let's just say at a minimum, it's not getting the impression that it's not a strictly enforced policy, but more kind of an intuitively applied, maybe perhaps inconsistently applied approach to managing the beds.
Okay, thank you. And that's something too, when Investigator Morse presents to commissioners, perhaps she can comment on this question that we have, Attorney Spalding. So thank you for your response.
You're welcome.
Any other commissioner questions for Attorney Spalding? Seeing none, you'll have 2 minutes and 41 seconds when we come back to you. Is there something here for red of light?
Director of Operations.
Okay, sorry, Victoria was the name that we had in our system, sorry. You have 10 minutes, do you want to save any of that time?
Yes, let me say.
When you're ready, go ahead.
Looking at the situation, it is our common practice that we typically wait a 3-day period prior to exiting somebody when they are in the hospital or they're somewhere else and we don't know what the outcome is. The reason that Mr. Manley was discharged on the 29th is because after 3 days, we still did not have a discharge date. It had gone back and forth where he initially reported he was having surgery and then later said that he didn't have surgery. Couldn't provide us with any discharge instructions or expectations. And because of the unknown, we did have a wait list, so we did have to discharge Mr. Alley at that time. Typically, when somebody leaves the shelter, we could immediately fill their bed. There's nothing saying we have to wait the 3 days, but we were trying to accommodate him and allow him time to be discharged and also prepare for what that discharge would look like. But because we still had no knowledge, we did discharge him. And then we exited him. He was later discharged from the hospital. But by that time, we had already moved on to the next person because ultimately we couldn't justify leaving a bed empty while we did have people on our waiting list. He was later given the opportunity to provide a pre-intake and be allowed to re-enter the shelter, but it never got to that point. He did call, I believe it was 3 separate occasions in July after completing his pre-intake. And then by the time a bed had become available, he was no longer calling to be reached. So we don't have any other information at that time to go based off that, and everything that was listed in the report seemed accurate, and I have nothing to argue about.
Commissioner Ryan.
Thank you. A couple questions. The first one, if it's in the record, what is the average length of stay, maybe average, and what is the how long our guests allowed to stay as long as they want in the shelter? I mean, is there a timeline there? And what's the average length of stay? And how quickly does the waiting list?
So the average length of stay is between 60 to 90 days. We do have some people that maybe have more barriers and they are required to stay a little bit longer while they're addressing their barriers. But we have other guests who move throughout the shelter and within 30 days they're out. So there's not really a concrete number, but the average length of stay is about 60 days.
Going back to the policy, is there anything, I mean, as Commissioner Sanders said, my first thought is, okay, well, it's tied to funding and I understand the funding issues. So is there something in writing, or is this a policy that you're able to just, willy-nilly, or talk to us about that?
We're actually encouraged by Maine Housing to keep our beds full. So they actually frown upon us holding beds open. We did hold it open for about 3 days, but our common practice is that we don't hold it open no longer than 3 days unless there's some sort of agreed upon time period. For example, if a hospital says they're going to discharge within 7 days and this is what the recovery time is going to look like, we can make an accommodation for that, but we didn't have any of that information at this time.
Thanks.
Yes, good morning. First of all, I appreciate your concise presentation, right? Like they're going to law school.
They gotta stop telling this.
For a lawyer. I need to retire. Yeah. So just a couple of clarifications. This call that was made to the hospital on the 29th, right? I don't know if you're familiar with the call, but it doesn't look like anybody actually spoke with complainants, right? It looks like somebody spoke with hospital staff asking about his discharge. Do you have any information about that?
So at the time, the case manager did call the hospital to inquire because she hadn't received a call yet that day. Later in that morning, it was around 10:30 in the morning when the case manager did actually speak with Mr. Manley, who at the time went back and forth and said he was having surgery, didn't have surgery, all within the same conversation, and still did not have a discharge date in mind. And then he was exited from our program at 11:30, and I do not recall the time he was discharged, but he was discharged after that time.
I missed that. So you did actually speak with him, you being the shelter, and he was unclear about his discharge himself.
Correct. Looking at the progress note from the case manager, that's exactly what she documented.
Then there's been this conversation about reasonable accommodation, right? In terms of either, as I understand it, holding the bed open or getting him back down, right? And my understanding, just based on common sense, is that once he's discharged, a reasonable accommodation would necessitate displacing somebody else. Is that right?
Yes, that is correct.
Because all your beds are full. You're under pressure to keep them full. True?
Yes, that is correct.
Thank you.
Commissioner Sanders.
Thank you. Along that same line of questioning, there's one piece of the investigator's report that's not quite clear to me, and I wonder if you can help us understand. In the investigator's report on the second day, the second page, it indicates that at approximately 11:30 a.m. on May 29th, right, the caseworker called the hospital to inquire. And at that point, the complainant didn't know, was equivocal, perhaps, about when he would be discharged. But in fact, it looks like he was discharged just perhaps a couple hours later on that same day. And I wonder, did the complainant call the shelter on that same day to say, hey, in fact, I've been discharged, I'm coming back to access that shelter bed?
So the complainant was discharged from the shelter around 11:30 a.m. The actual phone call took place about an hour prior to. It was around 10:30 a.m. And at that time, there was no updated information letting us know when he would be discharged. I have no record saying that he called back after he was discharged on that day. He may have, but I don't have that in front of me.
Okay. And the reason I ask is, if it's true, right, that the call happened at 10:30 on or about, the discharge happened at 11:30 on or about, and if he had called back right later that day to say, hey, I've been discharged, I'd like that bed, would it have been possible / appropriate for the shelter to have said, you know what, we just discharged you, but given the timing, it makes sense to re-enroll you. So in other words, you could have given him that bed back given the timing rather than moving to the wait list. Is that right?
If we discharged him at 11:30, we would have immediately gone to the wait list to try to move the next person in. So if we would have already scheduled or had somebody come in to fill that bed, then no, we wouldn't have been able to give it to him. But within several hours, we can typically get somebody in to fill that bed. But if we had not filled that bed and had not moved on to the wait list yet, then yes, we could have accommodated that.
Okay. And is that what you believe happened, that that spot had been filled before he ever called back?
Yeah.
Okay.
Commissioner Davis.
Attorney Spalding says that his belief is that the shelter was using this technicality of the policy as a pretext to get rid of a guest in the shelter that was high needs. My question is, does the record indicate how long he had been there and whether or not he'd had any other need to absent himself because of the medical condition and then come back? Is that in the record? Either one of those facts?
I would need to review the record, but he came in to our shelter on April 11th. So he had been there for about a month and a half. So there's no reason to believe that he would be discharged for any other reason. And no, it's not our common practice to discharge people because they're high needs. We would only have discharged somebody if it was such a high need that we were not able to accommodate them. If their need was more, for example, an assisted living facility or a medical facility, because we're not medical staff.
Right. And we don't know to what degree the condition was acute during that month and a half, but you were caring for him and knew he had that condition, right?
Correct.
Thank you.
Commissioner question for me, right? Have about a little more than 8 minutes and we come back to you. Attorney Spalding, you have 2 minutes and 41 seconds.
Yes, I'll just point out that, yeah, he was admitted to the shelter on April 11th, 2024. It is as part of the report that he had gone to the hospital before the visit on April 28th, 2024. And then, spent a day at the hospital, returned to the shelter, and then had
That's what I thought. Yeah.
Commissioner David, can you, Attorney Spalding still in the middle of his presentation.
Okay, so I was just emphasizing that I do believe that there is some evidence in the record that he was more high needs than going from April 11th to May 26th before having an acute issue with his Crohn's disease. I do agree that the RA analysis, the reasonable combination analysis that I've been discussing, would attach probably on May 28th or on May 29th before he was formally discharged. I understand that once the bed had been filled, the analysis is entirely different. It'd be unreasonable to physically remove a resident who had gotten that bed. But before, I think all the ingredients for doing the analysis were there before. They have stated that it would be potentially possible to keep a bed open for as many as 7 days. They say that they would have to be on notice about have clarity about the number of days at the time, but going beyond 3 days is possible. And I will just reemphasize again that what this progress note. I just believe quickly that I don't believe it is in the record that the shelter spoke to Mr. Manley on the 29th, that they called the hospital around 10:30, entered this discharge note that said nothing about the 3-day policy. And again, we're hearing a lot of emphasis about whether he needed surgery or not surgery. But what the progress note infers is that he had been dishonest about the need for surgery. Then the decision is made to discharge him from the hospital. Discharge him from the shelter. I have nothing else to add.
Commissioner David, do you have a question for Attorney Spalding?
No, thank you.
Any other commissioner questions for Attorney Spalding? None. Ms. Briggs, you have 8 minutes and 10 seconds if there's anything else you'd like to add.
I wanted to clarify the 7-day example that I used was an example. It wasn't a specific case in regards to a reasonable accommodation. And then that's all I need to say.
Any commissioner questions for Ms. Briggs? None, thank you. At this point, we've heard from the parties, and next we'll hear from Jane O'Reilly, who is presenting on behalf of Angela, who is out today.
Good morning, Commissioner. As I mentioned, I present Angela Morse, who was the investigator on the case. I reviewed the entire record. I've read the report. I've spoken with Angela about the case. And I have a few clarifications before I talk a little bit about the reasonable accommodation issue, and then I'll be happy to answer questions. The first is that the progress note that complainant's counsel is referring to, I don't believe says what he says it says. I did mark it in the report. It's basically a checklist that says why the person's being discharged and has checked hospital stay. Then there's an additional sort of progress note that says an exit interview was conducted and that the individual is in the hospital. It doesn't say anything, doesn't make any implications about a false statement or misleading statement or anything like that. So I wanted to clear that up. The other is about the issue of the policy and what's like in the record as a written policy. Respondent articulated it clearly. There is no written policy about a 3-day stay. That's sort of a general rule they have about sort of what's a practice that they have about keeping those rooms open. It's not a steadfast rule, meaning they could also extend it, right? If, you know, certain situations were in place, there's nothing that says they can't go past 3 days. What is written in the policy and what's given to everybody, including complainant when they enter the shelter, is that you have to return every night. So they were already sort of the policy that's given to them when they enter is, you know, have your bed. If you don't come back at the end of the day and call us and tell us why you're not coming back at the end of the day, we can give your bed to somebody else. So going from there in this issue of the policy. So the reason there's no reasonable accommodation analysis in the report is because it was not pled initially in the complaint. Complaint says that the complainant believes he was discharged because he has a disability. And in order for a reasonable accommodation analysis to be done, a request has to be made. I think that's already been sort of articulated a little bit in the questions that have been asked. But it's, you know, the Maine Human Rights Act does not require housing providers, employers, public accommodations to imagine what a person might need or imagine that a person does need something because they have a disability. A person has to make a request. They don't have to use the magic words, reasonable accommodation, but they do have to ask something. And at no point did complainant say, please, can you extend the policy or make any other type of request for an extension of his stay? He was aware of the policy when he went into the hospital. He'd been in the hospital before and come back. He knew sort of what the communication was supposed to be. And no request was made. So that's why the analysis is in the report. To answer any other question.
Heard from the parties and the investigator. At this time, we're looking at a motion. There is one proposed finding. Commissioner O'Brien.
I would recommend that to accept the report. There are no reasonable grounds to believe that federal plan administrates discriminated against Manly Alley on the basis of disability in violation of the Maine Human Rights Act. The complaint should be dismissed in accordance with 5 NRS 46122.
Moved and seconded. Any discussion? Being none, the motion is to find no reasonable grounds. If you are in agreement, we will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
The findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties confirming the results of the hearing. And could we take a 5-minute break?
Absolutely. I was just going to ask you if you want to take a break now or, and we will, and we'll reconvene just before 9 o'clock, 10 o'clock. I get confused. We'll be in recess.
You're muted.
Commissioner David, I think we're ready.
Okay, we'll call the meeting back to order, and the last case in the agenda this morning is a housing case H250148 A and B, Amanda Minks versus Sanford Housing Authority. Recommendation of our investigator is that we make a finding of no reasonable grounds to believe that unlawful discrimination existed, and therefore we will hear from complainant Amanda Minks or counsel.
Amanda, that's okay. Yes, please. Just, speak up as much as you can. The microphone is right underneath.
Yes, thank you. My name is Amanda Meeks. I live in Sunset Towers. My issue is with the tenant I share in literally wall with. I'm normally a very quiet person. I have agoraphobic, and so I rarely leave my premises. For the last year, it has been a nightmare. I have repeatedly begged housing to remedy the situation. They're stating that I demanded that the other tenant be evicted. That's not what I asked for. I asked if I could be moved or the other person could be moved. The other person smokes a lot of marijuana, and he is very violent and terrified of me. Can I read you something, please?
Is it in the record?
I don't remember. It's what the lease says.
Is the lease in the record, Newbert? Yeah, go ahead.
To conduct himself or herself and cause other we are obliged to conduct himself or herself and cause other persons who are on the premises with the tenants to consent to conduct themselves in a manner which is not will be disturbing to other tenants' peaceful enjoyment of their accommodation and will be conducted and maintained in the project in a decent and safe and sanitary condition. Also, it states that specific active, which by federal law results in immediate evictions, are illegal or other activities which impair the physical or social environment of the project, including but not limited to the criminal, threatening, assault, and or terrorizing other residents of management and self, drug-related criminal activities are off premises, not just near or threatening the premises. And then I'm going to skip down to part 13. Will not engage in disputive behavior and will not create difficulties with neighbors and will abide with the Sanford noise ordinances and maintain a respectful relationship within the property. The other tenant has not followed these rules. It is my belief that you're not going to like everyone. It's human nature. But it is my policy, if you do not like someone, you stay away from them. This person constantly stalking me. It's like there is a community room. He'll sit there and he'll watch and he'll come up and he'll try to engage me. I have always walked away. I've only said 10 words to him in the last year, which is, excuse me. He always tries to, sorry, I'm nervous. He always tries to engage an argument and then it blows up and then he plays the victim. The thing of it is, housing has condoned this behavior. They minimalize his behavior. In the building, it used to be
a home, a building for older people or handicapped people. And the last, I would say, 4 years, that situation has changed. The directors have changed, and the new person is very pro homeless people. So it went from people like 60 to literally 100 to people who are in their 50s to 60s, and most of them have drug and alcohol problems. It is a very toxic building at this point. And it's very, very hard to not have your home to be a sanctuary. And there is this boys club, and I'm not a part of it. And that is, they go downstairs and they kind of rule the roost. They're very boisterous. They drink alcohol down there, which is not allowed. You're not supposed to have any open containers at all.
That is 5 minutes. You can join if you'd like.
All right. But the main thing is, I think the other party issue is that there should be consequences to one's behavior. He is a racist. He uses the N-word. There's one gentleman that he calls him gay boy, and he's done this for 5 years. I just hope and you see what the situation is. This person it's just not me. There's like 8 other people that he's doing this to, and housing protects him. I thank you for your time.
Commissioner, question for Ms. Banks. Commissioner.
Yes, good morning.
Yes, sir.
And I want to say thank you for coming and presenting on your behalf. Nice job. I can see you're a little nervous. I think you do it well. What I'm curious about, I've read it. I'm hearing what you have to say, and it looks like from what I see here, right, that you had requested to move apartments, right?
Yes.
And I guess there's sort of 2 phases, right? The first request, at some point they asked you if things were still going on and you said no. And so, I mean, I'm just telling you what you don't have to tell you what the report. Yeah.
Okay.
And then I think the second phase is more important, where you sort of report to housing folks, you and your allies, that you have a medical issue, right? And it's important for you to move, right?
Yes.
At which point your request to move is granted, right?
No.
Well, that's what it says here. So I'm wondering.
Okay.
I guess what, and just so you can frame your comments, what I'm wondering is, if the report is correct that your request to switch units was in fact granted, what is it that you would like to see done?
Okay. First of all, it was not granted. The thing of it is I went to the place. I waited until August, correct? And I went to go see the building, and I was going to take it sight unseen. However, when I talked to the lady, I said, look, I need to know what it costs. I need to know everything, because I don't want to go into this blindly. I'm not going to sign things. The woman I spoke to became very agitated, and she said basically I was putting the horse before the cart, and that I did not have the apartment. What was going to happen was I got to fill out the paperwork. And then they wanted me to pay $1,300 for a deposit. My income is under 1,000. Also, I kept asking, what is the deposit? She just kept telling me to save my money. That is part of the issue, is that they minimalized everything and they keep changing. So the thing of it is, I have problems with my knees and I have a motorized chair. I would have had to get rid of 95% of my belongings, the apartment. I have 2 doctor's notes that this is my fault, I got to add, but I need a larger space. And The thing of it is this room is about the size of the apartment they wanted to give me. And also I would have, it's my understanding, got rid of my section 8. So,
So just so we're on the same page, what I hear you saying is that there's now dialogue about finding you a different apartment,
Yeah.
but there's not been an apartment suggested that fits your needs.
right,
Is that fair?
correct, sir.
All right, thank you.
Any other commissioner questions for the meeting? And we'll have about 4 minutes when we come back to you.
Do you want to go outside now?
No, you can sit right there.
Okay.
No, it's fine. Attorney Snyder, you have 10 minutes. You want to reserve any of your time?
Yeah, I'll reserve 3 minutes. Thank you.
Whenever you're ready, go ahead.
I'm again going to try to be pretty brief here. I'll defer to the investigators' report for the lion's share of the facts and analysis. But I'd just like to highlight the competing interests that Sanford Housing has to consider in situations such as this one. Sanford Housing cannot, based solely on the desires of another tenant, evict an individual properly residing on their property. An eviction is the most serious adverse housing action, and it is a statutory-based remedy that has strict prerequisites and requirements. The mere fact of a disagreement among tenants is not enough to infringe upon a tenant's rights. There's a quantum of evidence and facts that dictate the outcome. I hope that this in part allays Ms. Mink's concern that Sanford Housing is indirectly representing Mr. Kerrigan, as was sort of referenced in her statement of disagreement. Sanford Housing has at all times relevant here too acted promptly and appropriately to address Ms. Mink's concerns, investigate reports of activity inconsistent with Sanford Housing's policies, and has intervened when necessary and to the extent necessary. Sanford Housing has readily issued lease violations and notices to quit when it's been appropriate. For years, Ms. Minks and Mr. Kerrigan lived fairly harmoniously. The reports about Mr. Kerrigan's behavior started after a disagreement about a poster that was hung in a public common space in the building. And that happened late summer, early fall of 2024. Ms. Minks, in her statement of disagreement, referenced other tenants that have experienced issues with Mr. Kerrigan out of consideration of the confidentiality policies of the commission. I'm not going to reference that here, but if you have specific questions, I'd be happy to answer those. I will say it's Sanford Housing's practice to document, investigate, and manage as appropriate all reports of misconduct that it receives. I think it's clear from the documentation submitted in Sanford Housing's response to the charge of discrimination that they acted consistent with those policies and practices. Ms. Mink's statement of disagreement seems to raise issues that are outside of the scope of the commission's purview, and outside of any relief that the commission could grant the complainant. I will defer to the commission to the extent that I'd like to address any of the questions that were raised in her statement of disagreement. But as far as the questions go about the handling of Sanford Housing's landlord-tenant issues, I'll reiterate that Sanford Housing has and will continue to address Ms. Mink's concerns consistent with its legal obligations and policies, which are enforced uniformly across all tenant issues. This includes enforcement of policies related to tenants having cameras that face common spaces in the building. I think that's something that was raised in the statement of disagreement. Sanford Housing has historically granted Ms. Mink's reasonable accommodations and has made every effort to address Ms. Mink's concerns promptly and appropriately. Upon receipt of a doctor's note, Sanford Housing granted her reasonable accommodation request to be moved. There's really only so much that Sanford Housing can do about the lack of inventory, especially where, as is the case with Ms. Minks, there's some additional, needs that she has medically to make that space safe and comfortable for her. So that's what I have for right now. I'm happy to take any questions from the commission.
More questions for Attorney Snyder? Commissioner Beck.
Yeah. Good morning.
Morning.
Busy day, huh?
Yeah.
Yeah, so I'm just wondering about her request to switch apartments, which
Mhm.
I understand that request was granted, right? If it's in the record, what's the status of that request? I mean, what it says in the record is she's at the top of the wait list. And
Yeah.
complainant has described at least one apartment that was sort of proffered and that in her view didn't meet her needs. So I wanted to get your perspective on where all that stands.
I don't have an up-to-date report as we sit here today. I know that there has been discussions with Sanford Housing about units in Maine, and there was also, I think, some discussion at one point about Miss Minks transferring her voucher and moving out of state. So I know that was something that was being explored at a certain point as well. I'm not sure as we sit here today where that stands. I do know that it's an active process that Sanford Housing is continuing to engage in.
All right, thanks.
Any further questions for Attorney Snyder? None, you'll, the 6 minutes when we come back to you. Ms. Minks, you can come back up.
Thank you, Ken.
You have 4 minutes and 5 seconds if there's anything else you'd like to add.
Yes, all right. There has been some misunderstandings. There is one particular person that works for the housing that has a very bizarre, that's the only words I can think of, relationship with the other gentleman. The thing of it is, one day I was taking trash out for another person, and he got it and had this hissy fit. She stated, and I quote, that I did not have the right to be downstairs with this other person. The thing of it is, I've tried my very best to communicate what my needs were. My issue is, at this moment, the other gentleman has a restraining order. I had a restraining order at one point against this other person. I was told that it did not matter, they would not respect it until it was a year long, and then he would be evicted. I don't want to see people homeless. That was never my goal. I would have been happy if they just moved from floor to floor. Like at this moment, there's like, I think 4 or 5 other empty apartments. I just don't want to share a wall with him because he smokes a lot of pot. It is against my religion. And it's the fact that I don't know what else to do. 95% of the time, they do not reply to me. And also, at one point, he's done this to me twice. I get on the elevator and he's pinned me in the elevator to where I couldn't get out. Housing edited the video to where it looked like I was just getting off the elevator. I would never get on the elevator with him because there's no cameras. The men are becoming more and more violent, and that is normally their place of choice because there's no camera.
Any commissioner questions for Ms. Minks? Hearing none, thank you. Attorney Snyder,
Thank you. I just have 3 very brief points. The first is that Sanford Housing has documentation and documented responses to every inquiry and complaint and report that Ms. Minks has made over the last, year or so since this has been going on, and, predating that to the extent that reports existed. They have documentation of that as well. The other thing that I just want to make really clear is that Sanford Housing did not manipulate or edit any of the videos that were submitted in relation to this case, this matter. And the third point that I had is escaping me, but just those two things I just wanna highlight as well.
Any commissioner questions for Attorney Snyder? Thank you. We will next hear from Newbert Leza, the investigator.
Good morning, commissioners. I don't really have anything to add. Both of the parties have presented their case just like they did to me when we were doing the conference and throughout the investigation. Everything that I found and everything that I think is relevant is in my report. But if you have any questions, I'm happy to answer.
Yeah.
Yeah.
Sorry, Commissioner Douglas and then Commissioner David.
Good morning. So, there's been some casual references to restraining orders. And I guess I'm not really, as I sit here right now, I'm not really understanding how that bears or doesn't bear on the complainant's allegations or complaints. You just shed some light on that for us. What do these restraining orders have to do with anything?
Sure. So there isn't a whole lot about the restraining orders in the record. There's some information that other tenants in the building have gotten restraining orders that have been granted against Mr. Kerrigan. They've mostly been temporary restraining orders. Once they've gotten to the actual granting of the permanent restraining order, that's actually never happened, at least not that was presented to me in the record. It didn't really bear very much on my investigation at all, to be honest.
Yeah, I guess the thing I wasn't clear about, just based on what's been said today, is the complainant doesn't have a restraining order against this individual, correct?
Not from my understanding, no.
All right, thank you.
Commissioner David.
Yeah, Nooper, it just seems to me, and I want to know if I'm reading your report correctly. You're not minimizing the hate and discontent between her and Mr. Kerrigan, but you're saying that you're not finding any tie to illegal sex discrimination or disability discrimination. Is that a fair summary of how you come out the way you do?
Yes, that's a fair summary.
Well.
Any other commissioner questions for the investigator? Seeing none, thank you, Newport. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There are two proposed findings. And the jeopardy of being. Make a motion. Playing in my head already.
Yeah, well,
Well,
you go ahead.
Go ahead. Go ahead.
You go ahead, Ed. I know I cut you off last time. You go ahead.
No. Yeah, I'll move that we find that there are no reasonable grounds to believe there was unlawful discrimination based on disability or sex in regards to both respondents, Sanford Housing and the individual.
Second.
And seconded, any discussion?
I mean, I'm bothered by the behavior, but I'm asking myself where we're being asked in effect to sort of micromanage the difficulties of a complex housing situation, and I'm not finding that there was unlawful discrimination based on those things, which is what our challenge is. I mean, maybe these complaints are more appropriate for Maine housing or something like that. I don't know where you go when you're in that situation, but I don't find unlawful discrimination.
I agree with what you're saying, that we can't find that there, or I trust that we're going to say that we cannot find that there sex discrimination. However, that I just want to say it took a lot of courage for you to do this and come forward. And I think you did a very fine job. It's just that we cannot tie that the Maine Human Rights Act, and that's the bottom line. Thank you.
Further discussion? Seeing none, the motion is to find no reasonable grounds on both recommended findings. If you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien. Yes. Commissioner Walker,
Yes.
Commissioner Douglas,
Yes.
Commissioner Sanders.
Yes.
The findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing.
Sure. I didn't know where else to go. No, because it's getting so hard. Yeah.
Thank you. Good luck. All right, so Ed, and I need a motion to go into executive session, and then I'm gonna look into it.
So moved.
Appreciate that. Ed,
Yes.
language that you have to use for this.
Yeah, I've got it.
Okay.
If you want to move, we go into executive session, consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission. That's a motion.
Second.
Seconded, any discussion? Okay. Commissioner Davis,
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas,
Yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
Okay, great. I'm gonna add Ed and May to the breakout room.
You want me to mute, right?
Oh, you're on mute, Kit.
Great. All right. Can you hear us now?
Yes.
Great.
Yep,
So
all set.
I need a motion not to litigate E23-0127 Christopherson versus Wayfair and E23-0218 Greiser versus the town of Machias.
So moved.
Any discussion? Being none, if you vote yes, you are in agreement. Commissioner David?
Yes.
O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay. Thank you all very much. We'll see you in October.
Thank you.
Is it November?
Okay.